dogging the Shadow Army, Bellion phases out before slashing it.
Yo, would y'all believe it's blocking me from going to go-to meeting? Yo, you gotta set up a new go-to. It ain't letting me in. You heard me? You gotta set up a new go-to. It ain't letting me in. All right. Peace to Yahoo. Peace to Yahoo. We having some technical difficulties right now. I don't know what's up. Yo, it is crazy. On my other computer, it's blocking me from getting on to go to meeting. It's really bananas, yo. They're blocking. This is why I got multiple computers. They're straight up blocking my IP address. What kind of crap is that? I really don't understand, man. I really don't understand. They always want to stop me from talking. They are really attacking me. So my pay stuff that y'all pay for my style, now they want to ask me for more information. So I take it they're gonna start messing with your ability to pay too. I gotta think about how I'm gonna get around that. Uh, they're attacking, yo. They don't like what I'm teaching y'all at all. So it's crazy. Now with all that happening, I forgot what I was gonna talk about today. With good reason. You know, they can't stop us. They could slow us down. Y'all know that, right? All right, I'm going to talk about a Supreme Court case called Cool, Coolidge versus New Hampshire. Coolidge versus New Hampshire. I don't even have a reason to have this computer open. One of the computers open. It ain't working. But it says Coolidge versus New Hampshire 403 US 443 1971. All right. Police went into petitioner's home on January 28th, 1964, to question him about a murder. In the course of their inquiry, he showed them 3 guns, and he agreed to take a lie detector test February 2nd. The test was inconclusive on the murder, but during its course, petitioner admitted a theft. In petitioner's absence, 2 other policemen came to the house and questioned petitioner's wife to check petitioner's story and collaborate his admission of the death. Unaware of the visit of the other officers who had been shown guns and knowing little about the murder weapon, the police asked about any guns there might be in the house and was shown 4 by petitioner's wife, which she offered to let them take. After one policeman first declined the offer, they took the guns along with various articles of petitioner's clothing his wife made available to them. His wife was a fucking snitch and an enemy of him, man. The way I see it, them damn women. They took the guns along with various articles of petitioner's clothing his wife made available to them. On February 19th, petitioner was arrested in his house for murder. And on that date, a warrant to search petitioner's automobile was applied for by police chief and issued by attorney general, who had assumed charge of the investigation and was later the chief prosecutor at the trial, acting as the justice of the peace. The car, which at the time of arrest was parked in petitioner's driveway, was subsequently towed to the police station, where on February 21st, the 2 occasions the next year, it was searched. Vacuum sweepings from the car, as well as other clothing, was used as evidence in the trial, along with one of the guns made available by petitioner's wife. Following the overruling of pretrial motions to suppress the evidence, petitioner was convicted at the state Supreme Court affirmed. Held. 1. The warrant for the search and seizure of petitioner's automobile did not satisfy the requirements of the Fourth Amendment and was made applicable to the states by the 14th Amendment because it was not issued by a neutral and detached magistrate, Johnson versus United States, 333 U.S. 10, 333 U.S. 14, pp. 449 to 453. So, did y'all know when they do a warrant, it has to be a warrant from a different jurisdiction, a different county, because the county that's doing it can't be a party. So this is what this Johnson versus United States says. They have to do it somewhere else. It has to be a neutral or detached magistrate. All right, let's go to the next one. 2, the basic constitutional rule is that searches conducted outside the judicial process without prior approval by a judge or magistrate are pro se unreasonable under the 14th Amendment, subject only to a few specifically established and well-defined exceptions. Page 403 to US 444. So, what did it say? Searches conducted outside of judicial process without prior approval by a judge or magistrate are per se unreasonable under the 14th Amendment. They have to have the warrant before they come and take your property. That should be obvious, yo. It should be absolute obvious. A, the seizure of the car in the driveway cannot be justified as incidental to the arrest, which took place inside the house. Even assuming or Gino that the police could properly have made a warrantless search of the car in the driveway when they arrested the petitioner, they could not have done so at their leisure after its removal. Page 43 US 455 through 457. B, under the circumstances present here, where the police for some time had known of probable role for the car in the crime, petitioner had ample opportunity to destroy incriminating evidence. The house was guarded at the time of the arrest, and the petitioner had no access to the car. There was no exigent circumstances justifying a warrantless search, even had it been made before the car was taken to the police station. The special exemptions for automobile searches in Carroll versus United States 267 US 132 and Chambers versus Maroney 399 US 42 are clearly inapplicable. CF Dyke versus Taylor Implement MFG Co. 391 US 216 pp. Page number 403 US 458 through 464. C, under certain circumstances, the police may, without a warrant, seize evidence in plain view, though not for that reason alone, and only when the discovery of the evidence is inadvertent. The exception is inapplicable to the facts of the instance case, where the police had ample opportunity to obtain a valid warrant, knew in advance the car's description and location, intended to seize it when they entered on petitioner's property, and no contraband or dangerous object were involved. Page pp. 403 US 464 through 473. And 3, No search and seizures was implicated in the February 2nd visit when the police obtained the guns clothing from petitioner's wife. Hence, they needed no warrant. The police, who extended no effort to coerce or dominate her, were not obligated to refuse her offer from them to take the guns in making these the other items available to police. She was not acting as an instrument or agent of the police. Page 403 US 484 through 490. And it says 109 NH 43260 A2D 547 reversed and remanded. Stuart J. delivered the opinion on the court in the Berger CJ as Part 3, in Harlan as Parts 1, 2D, and 3. Douglas Berman Marshall joined and filed coherent opinions. And dissenting the opinion in the portion of Part 1 and Part 2 and Part 3 of the Berger C.J. Blackmun joined, filed concurring dissenting opinion in which Berger C. joined post. Mr. Justice Stewart delivered the opinion of the court. We are called upon, in this case, to decide the issue of the 14th Amendments arising in context of the state's criminal trial commission, particularly brutal murder. In every case, our single duty is to determine the issues presented in accordance with the Constitution and the law. Once again, it's always about the Constitution. Did they stay within the means of the Constitution? Or you can get off. That's what we concentrate on, y'all. Pamela Mason, a 14-year-old girl, left home in Manchester, New Hampshire on the evening of January 13, 1964, during a heavy snowstorm, apparently in response to a man's telephone call for a babysitter. 8 days later, after a thaw, her body was found on the side of a major north-south highway several miles away. She had been murdered. The event created great alarm in the area, and the police immediately began a massive investigation. On January 28th, having learned from the neighbor that the petitioner, Edward Coolidge, had been away from home on the evening of the girl's disappearance, the police went to the house to question him. They asked him, among other things, if he owned any guns. He produced 3, 2 shotguns and a rifle. They also asked whether he would take a lie detector test concerning his activities on the night of the disappearance. He agreed to do so on the following Sunday, his day off. The police later described his attitude on the occasion of the visit as fully cooperative. His wife was in the house throughout the interview. On the following Sunday, a policeman called Coolidge early in the morning asked him to come down to the police station for a trip to Concord, New Hampshire, where the lie detector test was to be administered. That evening, 2 plainclothes policemen arrived at the Coolidge house, and where Coolidge was waiting with her mother-in-law for her husband to return. The 2 policemen were not the 2 who had visited the house earlier in the week, and they apparently did not know that Coolidge had displayed 3 guns for inspection during the earlier visit. The policewoman told Coolidge that her husband was in serious trouble and probably would not be home that night. They asked Coolidge's mother to leave and proceed in questioning Miss Coolidge. During the course of the interview, they obtained from her 4 guns belonging to Coolidge and some clothes that Mr. Coolidge thought her husband might have been wearing on the evening of Pamela Mason's disappearance. Coolidge was held in jail on an unrelated charge that night, but he was released the next day. During the ensuing 2.5 weeks, the state accumulated a quantity of evidence to support the theory that he was that he who had killed Pamela Mason. On February 19th, the result of the investigation was presented at a meeting between police officers working on the case and the state attorney general, who had personally taken charge of all police activities relating to the murder, and was later to serve as chief prosecutor at the trial. At this meeting, it was decided that there was enough evidence to justify the arrest of Coolidge on the click charge search of his house and two cars. At the conclusion of the meeting, the Manchester police chief made a formal application under oath for the arrest and search warrants. The complaint supporting the warrant for search of Coolidge Pontiac automobile, the only warrant that concerns us here, stated that the affiant has probable cause to suspect and believe, and does not suspect and believe herein offers satisfactory evidence that there are certain objects and things used in commission of said offense, now kept and concealed in or upon certain vehicle, to wit, 1951 Pontiac two-door sedan. The warrants were signed and issued by the Attorney General himself, acting as a justice of the peace. Under New Hampshire law in force at the time, all justices of the peace were authorized to issue search warrants. The police arrested Coolidge in his house on the day of the warrant issue. Mr. Coolidge asked whether she might remain in the house with her small child, but was told that she must stay elsewhere, apparently in part because the police believed she would be harassed by reporters if she were accessible to them. When she asked whether she might take her car, she was told that both cars had been impounded and the police would provide transportation for her. Sometime later, the police called towing company, and about 2.5 hours after Coolidge had been taken into custody, the cars were towed to the police station. It appears that at the time of the arrest, the cars were parked in Coolidge's driveway that, although dark, had fallen. They were plainly visible from both streets and from the inside of the house where Coolidge actually was arrested. The 1951 Pontiac was searched and vacuumed on February 21st, 2 days after it was seized again a year later in January 1965, and a third time in April 1965. At Coolidge's subsequent jury trial on the charge of murder, vacuum sweepings, including particles of gunpowder taken from the Pontiac, were introduced in evidence against him as part of the attempt by the state to show a microscopic analysis that it was highly probable that Pamela Mason had been in Coolidge's car. Also introduced in evidence was one of the guns taken by police on the Sunday evening visit to Coolidge's house, a 22 caliber Mossberg rifle, which the prosecutor claimed was the murder weapon. For conflicting ballistics testimonies were offered on questioning whether the bullets found in Pamela Mason's body had been fired from this rifle. Finally, the prosecutor introduced vacuum sweepings of the clothes taken from Coolidge's house that the same Sunday evening, attempting to show through microscopic analysis that there was a high probability that the clothes had been in contact with Pamela Mason's body. Pre-trial motions to suppress all this evidence was referred by the trial judge to New Hampshire Supreme Court, which ruled evidence admissible. The jury found Coolidge guilty and was sentenced to life imprisonment. The New Hampshire Supreme Court affirmed the judgment in conviction, and the granted Satori to consider constitutional questions raised by the omission of this evidence against Coolidge at trial. So now, first of all, the gun didn't match the murder weapon. Secondly, there was no evidence in the car. They had to keep on trying to conclude this microscopic evidence was gunpowder. So he could have gunpowder in his car from one of his guns. But let's go on. Now, in case y'all didn't notice, this case I'm reading to you has everything to do with warrants. And you'll see the point of this as I keep on. The petitioner's first claim is that the warrant authorizing the seizure of subsequent search of his 1951 Pontiac automobile was invalid because not issued by a neutral and detached magistrate. Since we agree with the petitioner that the warrant was invalid for this reason, we need not consider his further argument that allegations under oath supporting the issuance of warrants were so conclusory as to violate relevant constitutional standards. And they got case law. The classic statement of the policy underlining the warrant requirement of the 14th Amendment is that Mr. Justice Jackson, writing for the court in Johnson versus United States, 333 U.S. 10, 333 U.S. 13 through 14 page. The point of the 14th Amendment, which often is not grasped by zealous officers, is not that it denies law enforcement the support of usual inferences which reasonable men draw from evidence. Its protection consists in requiring that those inferences be drawn by a neutral and detached magistrate instead of being judged by an officer engaged in the often competitive enterprise of ferreting out crime. Any assumption that evidence sufficient to support a magistrate's distinctive determination is to issue a search warrant will justify the officer in making a search without a warrant would reduce the amendment to nullity and leave the people's homes secure only in the discretion of the police officers. When the right of privacy must be reasonably held to the right of search is a rule to be described by judicial officers, not by policemen or government enforcement agents. So it's telling you, and they're messing with the live on the gram. I'm not surprised. I am not surprised. This is what they love to do. Oh, wow. I didn't even go live on this shit. I forgot to go live on TikTok. And they still been harassing me all night.